Smith, and I would request 5 minutes for rebuttal.
5 minutes.
Thank you, Your Honor.
Certainly, go ahead.
In this case, we raised two issues. The first is that the state did not put up sufficient proof to prove beyond a reasonable doubt that Mr. Smith did not act in self-defense. And the second issue is that the state did not put up enough proof to prove beyond a reasonable doubt that Officer Sheeland suffered a serious bodily injury. For the purposes of argument today, I'm going to focus on the second issue. I would just note that this is an alternative argument, so this court would still need to first address the self-defense issue, but I think that the briefs sufficiently cover that, so I'm going to focus on serious bodily injury. For that, the state was required to prove two things. One, that an assault took place against Officer Sheeland, and two, that he suffered a serious bodily injury as a result of that assault. I'm not arguing that there wasn't an assault for purposes of this argument. I am saying that there was not sufficient proof for a serious bodily injury. That requires additional proof, just beyond the mere fact that an assault occurred. And there are 5 avenues, essentially, to get to serious bodily injury. Under TCA 3911-106, you have that there was an assault and it involved a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, and a protracted loss or substantial impairment of a function or a bodily member, organ, or mental faculty. In its response brief, the state appears to only argue that Officer Sheeland suffered a serious bodily injury either via extreme physical pain or a protracted loss or substantial impairment. But the jury was instructed as to all 5 of those options, so I'll just address them in turn if this court would like. For a substantial risk of death, full stop, the proof isn't there. The only medical treatment that Officer Sheeland testified that he received was for a superficial bite. I don't say superficial to mean that he didn't suffer a bite or that there wasn't an issue with that, but there was no...
The bite broke through his shirt, right? I mean, did it penetrate? No, okay.
No, there was no puncture. He just testified that he received a bite. This is what I mean by superficial, is that it didn't go through the skin. Okay. He didn't even really testify that there was any bruising. He did say that he went to the medical bay as a result of that bite, but that it didn't puncture. So again, that would not rise to the level of a substantial risk of death. Protracted unconsciousness, no testimony at all that Officer Sheeland was ever unconscious. Extreme physical pain, and this is one of the things that the state does argue. There was no testimony as to any pain or the extent thereof that Officer Sheeland ever suffered. So he did testify that he hit his head on the floor when all 3 of the men fell to the floor, that he was punched twice in the face. He said he presumed that he was kicked in the rear, and that he suffered a bite that didn't, again...
Is this the one where he had migraines for over a month?
That is the only testimony or evidence that was put forward that would even kind of go towards an extreme physical pain. He testified that he suffered a migraine for a month, but that eventually went away. There was no testimony about any kind of pain that is associated with his migraine.
A migraine in and of itself is painful. I mean, that's what a migraine is.
Well, I think that is a subjective understanding of what a migraine is. Everyone understands that a migraine means a headache, but there are also different types and different levels of migraine, to be sure. Without more testimony from Officer Sheeland about what he actually experienced, other than just to say, I had a migraine, there's not enough there to say that this rose to the level of extreme physical pain that is comparable with the other avenues for showing a serious bodily injury.
Isn't this, I mean, he hit his head on cement block. So isn't it a fair inference that that was pain? Well, he fell, or he was, it was a fight.
Yes.
In the jail. Or
yes.
Prison.
Yes.
And he was knocked down, and as a result, knocked his head on the cement ground. Mm-hmm. And then, as a result of that, had head injury, which caused him to suffer migraines, right?
So there's a difference between pain and extreme physical pain sufficient for a serious bodily injury.
Well, wouldn't extreme pain be consistent with over a duration of time, which he did testify to? I'm just,
So the time element is more focused on a protracted loss or a substantial impairment of a bodily function.
Okay.
So that is a separate and distinct element from extreme physical pain. And we have to look at all of these factors within context of each other. So to say that someone fell and hit their head, or that they suffered a migraine, is not to say that they didn't experience some pain, but it's not at the same caliber or the same level as a substantial risk of death, a protracted unconsciousness,
but aren't we
a protracted
given the
obvious
jury's
disfigurement.
ability to infer from the proof that was presented that this was?
So the jury, there has to be sufficient proof to show beyond a reasonable doubt. And to say that a jury can find beyond a reasonable doubt that there was extreme physical pain or protracted loss or substantial impairment of a bodily
Okay,
member.
well, let's stop there for a second. The jury heard that this individual was in a fight, was pushed down, head hit a concrete floor, suffered migraines that lasted over a month.
Lasted a month and then went away.
Okay, but lasted a month. And then the judge instructed him on all these things. And we presume that the jury follows the judge's instructions. He's saying that proof was insufficient for the jury to conclude that this was you could, I guess, go into protracted loss or of a bodily member, use of a bodily member. With if I thought about having a headache for a month, that'd be pretty debilitating.
But the problem is that a jury's speculation, or even as the state speculates in its
Well,
response
there's
brief,
proof there, though.
isn't.
The jury heard the witness.
There's proof that he fell and hit his head. There's proof that he was punched twice in the face, kicked in the rear, suffered a bite, and that he had a migraine that lasted for a month and then went away. But there was absolutely no proof put forward to provide any context for what any of that means, other than to just let a jury speculate wide open as to what does any of this mean. Had there been any testimony or follow-up by Officer Sheeland about, I hit my head and it hurt a lot, and it hurt for 30 days and I had a migraine, and the migraine caused me to have blurry vision or not be able to perform the functions of my job. If there was anything that put what he testified to in context as to what these actual standards are under the law, then there might have been enough to say that there was a serious bodily injury, but we don't have that. As it relates to extreme physical pain, he said that he hit his head on the ground, but there's no context for that. He didn't say that it hurt. He just said that he hit his head on the ground. And it's not what we subjectively think that might mean. It's what did Officer Sheeland actually experience. And that's what the state's burden was to prove as it relates to serious bodily injury. There also was no testimony about any protracted loss or obvious disfigurement. At most, we could get there as maybe a bruise on the arm, but we don't even have testimony to support that. So then also for protracted loss and substantial impairment, it's kind of along the same lines of what we've all been talking about here. There was testimony by Officer Sheeland that he suffered a migraine for a month, so we have a time element, but we don't have any testimony about a loss or impairment of a function of a bodily member or an organ. He just says that I had a migraine. But again, without more, without saying how that impacted him, there just simply was not any proof to elevate this to something that is akin to a substantial risk of death or any of the other factors. So what it really boils down to for protracted loss is that, yes, there's a length of time, but there's no proof as to any loss for that element. I would also just note, I'll leave that where it is for substantial bodily injury unless this court has any issues or questions. I would just note that there was, this relates more to the first issue probably for self-defense. There is a video of this incident that was recorded from the prison, and this happened in 2015. And most of what I'm about to say is not on the record. But from my own dealings going back and forth with the original trial attorneys, IT departments, there was a changeover at some point where this video from 2015 was no longer supported. And it was an issue at trial where the IT department for the DA's office had to get involved. And I don't know what it means, but they said they built a computer. All that to be said, I was never able to get the video to play. The state was able to get the video to play. They have, I guess, newer computers than what we're given at the PD's office. So I have reviewed that video, and I hope that this court will also be able to review the video. But as it relates to the issues that were raised,
Is it in the record?
the video is in the record.
Okay, you just don't know whether or not we'll have the computer.
That's right. I wasn't able to view it. My IT department wasn't able to get me access to it. It worked great for the state. I don't know what, I have no idea what's going on. I don't think that this clerk's office IT department could get it to play either. But the video, as I view it, essentially tracks with both Officer Coleman and Mr. Smith's testimony. Their testimony differs a little bit. The video quality isn't great. I don't think that it is a smoking gun, quite honestly, for either side, and I recognize that the burden has now shifted because Mr. Smith has been convicted. But I did just want to let this court know that there is a video of the incident, and the state and I have both been able to review it, and whatever I can do to help this court be able to view that video, I'm certainly happy to try and do that as well.
Doesn't sound like you can help us at all with it, just to be honest.
I'll make the offer.
Thank you for the offer.
I'll make the offer, yes,
Yeah.
but I personally lack any skill or capability to actually follow through on that, so you're right.
We'll get the state's IT person to help us if we have.
Hopefully.
You would think we would, as the all-powerful Court of Criminal Appeals, we'd have some
Yeah.
IT folks that could help us, but who knows?
This might be a good opportunity for the judiciary to ask for new computers if that's what it takes to get it to play. So.
We got good folks over at the AOC, I know. that
Okay.
They come to our office often to help us elderly judges try to figure out how to turn their computers on and stuff like that.
That's nice. They try and help me. I don't think that it works. But so anyway, I just wanted to make the court aware of that. And I would also
What
just
was
ask.
this was raised in the MNT clearly. What was the trial court's denial based on, or did they give a specific reasoning for determining that it was serious bodily injury?
So the trial court at the motion for new trial, it was a blended motion for new trial and judgment of acquittal, and the trial court actually found that Officer Sheeland had a headache for a long period of time, and this is a quote, after this, and that he still was suffering periodically from headaches, and he attributed those headaches from the incident that happened between him and Mr. Smith. So the jury weighed all that. I think in their experience, they found that was a serious bodily injury, and I can see where they found that. He also says, I could have seen also where they didn't, so I'm just going to deny the judgment, or deny the motion.
Okay, thank you.
Yeah, so basically recognize that the baby could be split and affirmed anyway. But we would ask that this court vacate the conviction for serious bodily injury and send down an order for a judgment for simple assault. Thank you.
All right, thank you, Mr. Raines. All right, General Douglas.
Good morning, Your Honors. May it please the court, Davey Douglas on behalf of the state. This court should affirm the judgments of the trial court because the evidence here is sufficient to sustain the defendant's convictions for aggravated assault. And regarding Officer Sheeland, there is sufficient evidence for a rational trier of fact to find that he suffered serious bodily injury through either experiencing extreme physical pain or the protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. And starting first with the extreme physical pain, the jury heard Officer Sheeland's testimony about the altercation with the defendant, and they also were able to watch the altercation itself. They were able to see the defendant take him to the ground. They were able to see him hit his head. They were able to see him get punched. And then they heard testimony from Officer Sheeland that he had a migraine, which is in and of itself a debilitating type of headache. And then he also testified that he had that migraine for a month. And so just alone based on the video and testimony that he had a migraine, that itself would rise to the level of serious bodily injury. And while there's not a requirement, a temporal requirement for extreme physical pain, it could be in a matter of seconds. It's relevant here that he testified he experienced that migraine headache for a month. The fact that it lasted so long goes to the idea that this was extreme physical pain. This was not just simple assault. And the subjective nature of pain, that's a question for the jury. And based on the evidence that the jury had here, particularly the testimony that this migraine headache lasted for a month, the jury could draw on its own sort of common sense understanding of a migraine, its own common sense experience to determine that that rose to the level of serious bodily injury because it was.
Let me ask you, that Mr. Smith's making the argument that more information needed to be given to the jury because it could have been, there's migraines and then there's migraines. And that the defendant the victim didn't really go into a lot of detail about how much pain we're talking about, how it affected his life or anything like that to show it was protracted. What is your response to that?
My response to that would be that the video and Officer Sheelan's testimony here is sufficient when it's viewed in the light most favorable to the state. Would it have been nice if we had more testimony? Absolutely. But here with the video and then that very specific testimony about a migraine headache that lasted for a month, that's enough for a rational trier of fact, again, drawing on sort of common sense experience and life understanding.
How are we supposed to know that this is, like what Judge Campbell said, migraine / I gotta take an Advil and to dissipate, versus migraine, I cannot, go into work sort of kind of thing. And, so how are we supposed to know that which one was applicable here? Because the state didn't elicit that kind of proof.
No, Your Honor, the state didn't elicit that kind of proof, but both of those inferences, I think, are reasonable from testimony of a migraine lasting a month. And when this court reviews the sufficiency of the evidence, it draws all the inferences.
But he went to work.
The proof at trial.
I don't trust, I don't want to state the proof, so I don't want to get you caught up, because I've read a lot. So don't trust me on that, but go ahead.
But I think one of the issues here was that there was additional proof put on at the sentencing hearing that didn't come in at trial. So we didn't have any testimony from him at trial for the jury to consider about whether he went back to work. Okay. But we did have testimony, again, about that very debilitating type of headache and the length of that headache. And a reasonable inference for a juror to draw from that is that this was extreme physical pain, or he experienced the symptoms that are typically associated with a migraine, which would result sort of in the protracted loss or substantial impairment of a bodily function. Some of those common symptoms, blurry vision, inability to stand for.
But none of that was testified to, right?
It was not explicitly testified to, but again,
I guess my fear is the slippery slope that we often find ourselves in when we're trying to determine the difference between a simple assault and an ag assault. And if we agree with you, we're going to have a case out there that says, hey, migraine, constitutes serious bodily injury, folks, so we're going to have a lot of class, C felonies out there now, where there's a big difference between migraine and, somebody getting their eye poked out, which I think happened to the other officer. I don't know.
I certainly understand the concern, Judge McMullen, and I think what does make this case, though, a little unique is that we have the video of the assault, too. And again, we're drawing all of the inferences in the light most favorable to the state. The video, coupled with that testimony, specifically saying a migraine and one that lasted for a month, a rational trier of fact here could have found serious bodily injury. If this was just testimony that I had a headache, that's potentially a different story. But here, the testimony and the video was enough for a rational trier of fact to find serious bodily injury here. And just one final point, two final points on the video. The state was able to play that video. I invited defense counsel to the office. We watched it together, and
Is it a magic computer?
to my knowledge, it's not.
Well, let me ask you this, because sometimes they have a proprietary player that you have to download to view it. Do you know whether y'all have done that?
I think we might have software like that. Honestly, what I did is just put the disc in, and then I had to click through a couple different options, but once I finally found the folder that had the video files, I was able to pull it up, and I will say it shows multiple different camera angles, but you can only watch one at a time.
Okay.
But the video, it shows sort of the interactions between the correctional officers and the defendant leading up to the altercation. It shows the altercation starting, and then it shows them spilling into the kitchen where the altercation continued. And one final point about the video, it does not track the defendant's testimony. It actually contradicts the defendant's testimony. He claimed that Officer Coleman was raising his radio to the side of his head. The video does not show that. What it shows is him normally reaching for his radio and then actually taking a step back from the defendant. It is then the defendant who lunges at Officer Coleman to initiate the attack. And based on that video and the testimony of the officers, the evidence was sufficient to sustain the defendant's conviction here. And unless there are any further questions, we would ask this court to affirm the judgment of the trial court. Thank you.
All right, thank you, General.
Thank you, Your Honors. I'll first just start with the last point that the state made. Hopefully this court will be able to view the video. I think that as many of us that have watched it will all probably have our own different takeaway that comes from that. So I still contend that it supports portions of both Officer Coleman's testimony as well as Mr. Smith's. And again, I recognize the burden that I'm under for that. To focus back on the serious bodily injury aspect, the point is that there was no context to Officer Sheelan's testimony. I'm not trying to say that he didn't suffer some kind of pain or that he didn't experience something, but there was no context, there was no more given to let a reasonable juror understand that what he went through, even though it's depicted on a video, which I believe the physical altercation lasts less than 5 minutes. But to let a juror know that either the physical pain that he suffered or the protracted loss or substantial impairment equates to the other factors for serious bodily injury, which are more than just that hurt, that was painful. It is a serious bodily injury that is akin to a substantial risk of death, a protracted or obvious disfigurement. This is more than just, I hit my head, that hurt, I had a headache.
But it sounds to me like from what the record shows, that it was more than just, oh, it was a headache. They see the altercation, they see the officer hitting the floor, concrete floor. Jurors can think about, boy, I bet you that really hurt, just from my experience of hitting my head. And then the officer testifying that as a result of this, I had a migraine for a month.
But again, it's Officer Sheeland who has to suffer a serious bodily injury. And to just say that I recognize that he hurt is not enough to say
But he said
that he
migraine,
suffered.
and again, I think, we talk about, does any rational trier of fact, whether viewing the evidence in the light most favorable to the state, any rational trier of fact would have found that the elements of the offense were met. And again, that's the standard we have to go under. And in this case, it wasn't just his testimony. He said it was a migraine, and they saw the video, and they saw him hit his head on the concrete. You're saying that no rational trier of fact could have found the elements of the offense?
Yes, Your Honor, because even taking that and giving credence to the state for it, it's still not sufficient to show a serious bodily injury that is akin to a substantial risk of death, a permanent disfigurement or impairment, a protracted loss of a protracted loss or a significant impairment of a bodily function or organ or mental capacity. You have to look at the context with which Officer Sheeland experienced those things and then compare them to the standard, which is the TCA code. And it is the code requires specific proof such that a serious bodily injury was shown. And it was not, that is not the case here. No rational trier of fact could have looked at that video, could have heard Officer Sheeland testify that, oh, I hit my head, I got punched twice, I got kicked in the rear, I got bit. The bite is the only thing that I received any medical treatment for. And then one last follow-up, oh yeah, by the way, I had a migraine for a month. All of that within context does not prove a serious bodily injury. It absolutely shows that an assault took place, but it does not rise to the level of a C felony. If there are no further questions, then again, I would just ask that this court vacate the conviction for the aggravated assault after first analyzing the self-defense, and if you find that that's not warranted, and then remand with instructions for imposition of a simple assault. Thank you, Your Honors.
All right, thank you. Both briefs were excellent, and we appreciate that. We'll consider those and get an opinion out in due course. All right, I think that concludes the morning